The criminal justice process. Once arrested, officers must inform the accused that she has the right to remain silent, meaning she does not have to answer any questions. But if she speaks, the statements that she makes can be used against her in a court of law. She also has the right to consult with an attorney or have an attorney appointed if she cannot pay for one, and the right to have an attorney present during questioning. Within 48 hours after an arrest, the accused must be taken before a judge. The judge must inform the accused of the charges against her and whether there is an affidavit or sworn statement supporting the charges. The judge must also advise the accused of her right to retain counsel or have counsel appointed if she cannot afford a lawyer, and the procedures requesting an appointment. She has the right to remain silent, but if she decides to make a statement to the police or court, then the statement may be used against her. She has the right to have an attorney present during any interview with peace officers or attorneys representing the state, to terminate the interview at any time, to conduct an examining trial, which is a hearing to establish reasons for her arrest or probable cause. In addition, the judge is required to give her reasonable time and opportunity to consult with her attorney and set a reasonable bond if allowed by law. If the accused cannot post the bond and remains in jail, then the prosecutor must file the charges against her by complaint, information, or indictment within 15 days for a Class B misdemeanor, 30 days for a Class A misdemeanor, or 90 days for a felony. Otherwise, she is entitled to be released without a surety under a personal recognizance bond. If the accused is not in jail, then generally the prosecutor has up to 2 years from the date of the offense to file misdemeanor charges. Otherwise, the case is dismissed and can never be prosecuted. In a felony case, depending upon the specific offense, the prosecutor may have up to 5, 7, or 10 years to file charges. For some serious charges, such as murder, sexual assault, and indecency with a child, the prosecutor does not have any time limitation to file charges. Once the charges are filed, the accused must make an initial appearance or arraignment. The court will give her a copy of the charging instrument, complaint, information, or indictment, and she will have an opportunity to have the charges read in open court, enter a plea, and request a continuance if needed. Most cases are continued or reset for announcement settings to allow for further investigation by the defense, the prosecutor, or both. At the arraignment, the prosecutor will usually allow the defense attorney access to the state's file, including the police offense report, convey an offer or enter into plea negotiations, and entertain requests for access and copying of evidence, such as scene videos, 911 calls, and confessions. The defendant has the following rights, and they are continuous. The presumption of innocence until proven guilty, which means the prosecutor has the burden to prove the defendant's guilt beyond a reasonable doubt. The defendant also has the right against self-incrimination, meaning the defendant does not have to testify. The right to a speedy trial by an impartial jury, the right to confront or cross-examine the state's witnesses, the right to subpoena witnesses to testify for her, and the right to appeal. A defendant may waive most of these rights, but should only do so after talking to an attorney. Several procedures or hearings may occur before the trial. Most of these, such as bond reduction hearings and motions to suppress, are actions that lead up to a trial. They are important to the progress of the case. At a bail hearing, the judge may place certain conditions on the accused to make sure that they will return to court if released from custody. All individuals, except those charged with a capital murder, have a right to be released on bail if they can provide sufficient collateral. Bail is set within the court's discretion and on a case-by-case basis. If bail is too high, a defense attorney can request a bail reduction hearing. The defense attorney needs to show that the accused does not have enough collateral to pay such a high bond, is not a flight risk, has ties to the community, and is not a danger to the public or the alleged victim. There are instances in which a judge can deny bail, and if bail is denied, a defendant is entitled to a hearing within 48 hours of her arrest. To be released from custody, a bond must first be posted. Cash bond is when a defendant pays the full amount of the bond in cash to the sheriff. The money will be refunded once the case is over. Bail bond is when a defendant uses a bonding company or bail bondsman to borrow the collateral. The bondsman will charge a fee and may require additional conditions on the defendant. The fee will not be refunded once the case is over. The third kind is a personal recognizance bond, or PR bond. This is when the court uses its discretion to release the defendant without requiring a surety or other collateral. PR bonds are not an option in some serious felony offenses. Before trial, the defense lawyer may file a motion to suppress. A motion to suppress is a way to keep out evidence that was obtained by the police in violation of a defendant's legal rights. For example, a defense attorney may file a motion to suppress if the police seized evidence from the accused without a proper warrant or forced a confession from a defendant. In a DWI prosecution, a defense attorney may file a motion to suppress if the police did not have reasonable suspicion to pull the defendant's vehicle over for violating a traffic ordinance. When the court grants a hearing on a motion to suppress, the court can rule based on the motion itself, upon opposing affidavits, or upon oral testimony. The accused's criminal defense attorney will talk to the state's attorney to try to negotiate a plea bargain, or a deal on her behalf. The defense attorney must inform her client of all reasonable offers made by the state's attorney. A plea bargain may require the accused to plead guilty instead of no contest, and may require waiver of certain rights. If a plea bargain is made and agreed to by both sides, the judge is not obligated to accept the deal. It is only a recommendation being made to the judge. If the judge rejects the plea agreement, the defendant can withdraw the plea of guilty or of no contest. Approximately 98% of all criminal cases are resolved with some form of plea bargain. Discovery is the process by which information about a case is exchanged between the prosecutor and the defendant. The accused may file a motion for discovery either before or during trial. Texas does not have automatic discovery. The accused may request to inspect and test evidence, gain access to audio, video, photographic, or electronic evidence. Examples of evidence that may be considered material and that may be in the control of the state or its agencies are any designated documents, the written or recorded statement of the defendant, books, photographs, or objects, or tangible things like guns or drugs. The defendant is not entitled to written statements of witnesses and the work product of the prosecutor or the prosecutor's investigations, such as police offense reports. Both the defense and the state may request the other side to disclose the name and address of each expert witness that may be used at trial. Either side is entitled to take depositions of witnesses upon application and approval of the court if the witness may be unavailable for trial due to age, infirmity, or military deployment. The state, but not the defense, may depose an elderly or disabled person who is the alleged victim of or witness to an offense for the purposes of preserving the person's testimony. If the court grants the defense's motion for discovery, the defendant's inspection of the items must be in the presence of a representative of the state. The three phases of the trial include, first, jury selection, and then there are two more phases in Texas, the guilt or innocence phase, and third, the punishment phase. A jury trial is the first type of trial. Every defendant has a right to trial by jury in Texas for both guilt, innocence, and punishment phases of the trial. A defendant may waive his right to jury trial if the state agrees and have the judge determine guilt, innocence, and then assess punishment. You can also have a plea of guilty with a pre-sentencing investigation. A defendant may also waive a jury trial at the guilt, innocence phase and plead guilty without any sort of plea bargain and have a judge or jury assess punishment within the range of punishment. The court may order a PSI or pre-sentencing investigation to determine the facts of the case, of the offense, the defendant's criminal history, and the victim's wishes for punishment. The defendant's attorney should discuss all the pros and cons of a plea agreement, jury trial, trial by a judge, and pleading guilty without a plea bargain and ordering a PSI. The process of selecting a jury is known as voir dire. During voir dire, a panel of people will be questioned by both sides about their background, beliefs, and biases. The jury will be selected from this larger panel. The goal of jury selection is for both sides to identify unqualified jurors, potentially biased jurors, and unfavorable jurors to eliminate them from the pool of potential jurors. The first 6 in misdemeanor cases or 12 in felony cases remaining will be selected for the jury. Each side has an unlimited number of challenges for cause. Usually, a challenge for cause is made when one side believes that a prospective juror has a bias against them. For example, a prosecutor in a capital murder trial might challenge a prospective juror who says that she objects to the death penalty because of her religious beliefs. The defense attorney might challenge a prospective juror who says that he believes that any defendant who does not testify is guilty. Such a point of view contradicts the Fifth Amendment of the Constitution. Each side may make a limited number of peremptory challenges. That is, each side can simply strike a certain number of prospective jurors from consideration. A peremptory challenge does not have to be explained. The number of peremptory challenges varies according to the type of trial and the number of defendants. In the typical felony trial, each side is entitled to 10 strikes. In the typical misdemeanor trial, each side is limited to 3 strikes. There is one exception to peremptory strikes. The state may not make strikes based on race. That is, the panel may not strike African American or Hispanic panelists because the defendant is the same race or because the prosecutor believes that minorities are soft on crime. When a defense attorney believes that the prosecutor may have made improper race-based strikes, he will make a Batson challenge. A Batson challenge, named after the U.S. Supreme Court case that forbids race-based strikes, requires the prosecutor to show that his strikes were not racially motivated. The guilt-innocent phase is the part of the trial where the state will attempt to prove that the defendant is guilty of a particular crime. The state will present evidence such as witnesses, lab reports, audio, video, etc. The defense attorney will have the opportunity to cross-examine the state's witnesses and present a case on the defendant's behalf, including calling defense witnesses to testify. At the start of the trial, the prosecutor will read the charging instrument to the jury. The prosecution must then make an opening statement. The defense lawyer may make an opening statement or postpone it until later. An opening statement must not contain arguments. Rather, the opening statement must only describe the facts that the prosecutor and defense lawyer believe the evidence to be presented will show. After opening statements, the state will present evidence through its witnesses. The defense will have an opportunity to cross-examine the state's witnesses. After the state finishes its case, the defense may elect to present evidence. After the defense finishes its case, the state can call rebuttal witnesses. The defense can then follow with other rebuttal witnesses. Types of evidence. First, testimony. Testimonial evidence is simply a witness giving testimony under oath about the facts of the case. Second, documents. Documentary evidence mainly refers to writings on paper, but also applies to other ways that information is preserved. Documentary evidence includes, but is not limited to, police reports, diaries, letters, contracts, photographs, tape recordings, and a printed form of digital evidence, such as emails or text messages. Third, tangible or physical evidence means objects and things that a judge or jury can physically hold and inspect. Fourth, demonstrative evidence. This is evidence used to show or demonstrate the testimony of a witness. Types of demonstrative evidence include charts, maps, and diagrams. For evidence to be considered by a judge or jury, the evidence must be, first, relevant. Evidence is relevant if it has any tendency to make a fact of consequence more or less probable than it would be without the evidence. Material. Material evidence is evidence that is related to the issues being decided in your case. Third, authentic. Even if evidence is relevant, you still must authenticate it. Authentication is the process by which evidence is proven to be genuine, real, and not forged or fake. Often, evidence is authenticated through testimony of a witness with knowledge. Some kinds of documentary evidence are self-authenticating, which means that they do not need any proof of their genuineness beyond the documents themselves. Fourth, evidence must not be privileged. Even if evidence is relevant, it will not be admissible if it is covered by a privilege. Certain information is privileged, which means that it does not have to be disclosed or discussed by the opposing party and cannot be asked about in testimony. Privileges recognized in Texas include, but are not limited to, lawyer-client privilege, spousal privilege, doctor-patient privilege, and privilege for communications to a clergy member. Once all the testimony is finished, the judge will prepare a jury charge. The charge contains law and instructions to help the jury decide the verdict. The charge is prepared outside the presence of the jury. The charge is then read to the jury. The prosecutor and the defense counsel then make their closing arguments to the jury. The jury is given a copy of the charge, and they decide the verdict in secrecy. If the jury cannot reach a unanimous verdict, the judge can declare a mistrial. A mistrial means that the trial concluded without a decision of guilt or innocence. A mistrial can also occur during the trial if one side violates certain rules of evidence. For example, if a defendant has a past criminal conviction, the prosecutor usually cannot mention it during trial. If the prosecutor improperly brings up the criminal conviction, the judge will probably declare a mistrial. When a trial ends in a mistrial, the state may usually try the defendant again. However, sometimes a mistrial suggests to the state that they have a weak case, and they will dismiss the charges. If a defendant is found guilty, a punishment phase determines the sentence. In Texas, the judge is the default choice to decide the sentence. However, a defendant has a right to have a jury decide the sentence. The punishment phase is similar to guilt-innocence in that both sides make opening and closing statements and put on witnesses. However, almost any information about the defendant can be considered in the punishment phase. The state may prove up the defendant's prior criminal record, put on witnesses to testify about the defendant's character, or try to prove that the defendant committed other bad acts. Basically, the state can ask the judge or jury to consider much more information about the defendant, information that would not be allowed into evidence during the guilt-innocence phase. Defendants convicted of a crime generally have a right to appeal the conviction unless they previously gave up that right to appeal as part of a plea agreement or agreement with the state. The appeal process begins with the decision of whether to file a motion for a new trial. These motions are only granted in a few limited situations, such as jury misconduct. The defendant should always consult with her lawyer to determine whether this step is necessary or beneficial, depending on the facts of the case. The second step in the appeal process is the filing of a notice of appeal. The deadlines for filing the notice of appeal are strictly enforced in criminal cases, and therefore, the accused should file the notice of appeal as soon as possible. The third step in the appeal process is the preparation and filing of the record on appeal. Unless a determination has been made that a defendant is indigent, they are responsible for making arrangements to pay for preparation of the record. Failure to do so may result in dismissal of the appeal. The last step in the appeal process is the preparation and filing of the briefs on appeal. Briefs are to help the appellate court with the history, facts, and legal issues involved in the case. After the briefs have been filed, the appellate court begins the process of deciding the case. The time it takes to decide an appeal varies greatly, depending on the complexity of the case. If the court rules against the defendant on appeal, her options going forward are very limited. She could file for review with the Texas Court of Criminal Appeals, which is the highest criminal court in Texas. However, review is rarely granted by this court.